Hello, everyone. This is Tyler Crone with the Thundering 36. We are so excited to have Mike Diaz here with us this afternoon to interview and tell us a little bit more about his race for the Washington State Supreme Court. Over to you, Mike, and welcome.
Great. Thank you, Chair Crone. And thank you to everybody who's on the meeting right now and those who might be watching later on. My name is Mike Diaz. I'm a judge on the Court of Appeals and a candidate for the State Supreme Court Position 3. I actually grew up partially in Ballard. I spent my elementary school years before moving down to White Center as a kid. But that was after I immigrated here from Peru. And I've been in the law for over 25 years, 10 as a federal civil rights lawyer, and I'm in my ninth year of judging. But never before have I seen the rule of law under attack, judges under attack, and the federal government trying to take away our rights as I have now. Never have I seen the opportunities I had as a kid growing up in Ballard, even growing up as an immigrant of indigenous descent. I've never seen those opportunities being threatened as I have now. And I do believe it's our state government, it's our state courts who will protect our rights, at least in this Washington, and who will provide the next generation the same shot I had as a kid to fulfill my potential. I know what it's like for parents to speak a little English, have no money, little education, no connections, and be unseen. I know what it's like then to struggle to overcome each barrier. And I've never been afraid to take on the fight for others. I was a federal civil rights lawyer who defended the rights and freedoms of the most vulnerable, including leading the reforms of the Seattle Police Department, which we put under a consent decree. And I was the federal civil rights lawyer who founded the Civil Rights Unit here in Seattle. And I was one of the people who President Obama nominated to be a federal judge for that work, but was stymied by Mitch McConnell. As a judge, I chair a commission that ensures that non-native English speakers have the same access to our justice system as all people. I educate other judges on how to maintain the integrity of our courts against ICE enforcement, for example. And I'm the only candidate in the field who has both trial court and appellate court experience, having written over 200 opinions in all areas of the law. So I'll be ready on day one. And I'd be honored to receive your endorsement when the time comes so I can continue the fight for our rights and freedoms in the face of historic assaults to make sure my story is still possible for the next generation of Washingtonians, wherever they come from. And with that, I'd love to get to your questions.
Thank you so much. Anita?
The first question, how would you approach cases asking to overturn long-standing judicial precedents, especially for cases that were decided a long time ago when Washington State looked differently than it does now?
Great. Should I be waiting for a timer here?
You can just dive in and we'll catch up. I'm
Okay.
sorry, I've now messed it up.
No,
Amanda, would you mind restarting and we'll start from the top? Yes.
no problem. Thank you for the questions. Extremely important one. I actually teach a class at Seattle University Law School called Washington Constitutional Law. It answers questions exactly like this, especially when balancing the federal constitution against the state constitution, when to apply one, when to apply the other, how to navigate the space in between those. And that includes overturning long-standing judicial precedent. The rule is pretty simple in concept. Was the prior ruling wrong? A. And B, was it harmful? That's kind of, you'll hear that a lot maybe from every judicial candidate. But I don't think, unless you've done appellate work for a good chunk of time, I don't think you understand, one who understands how to balance, how to establish those two things, and then how to then write about it. So on the one hand, something may be wrong, might be intuitively wrong to us, but you also have to understand that I believe that precedent is very important, and it creates stability. It allows lawyers to advise their clients. It allows people to make decisions in everything from how to draft a will to whether what they're gonna might receive in a divorce to a business dispute or something. So we proceed very carefully, and what wrong means it was wrongly decided from the very beginning, that there was something fundamentally incorrect about the way the court analyzed the issues, the way the court reached its conclusions, and finally, whether it's harmful. Does this matter? And our Supreme Court, for over the last 20 years, I've taught classes on every single one of the major cases that have become our Supreme Court, bringing in the subject matter experts on each case, whether that involves racial injustice issues, education, the death penalty. And we've analyzed from a million different angles what wrong means. And I would apply that knowledge to this issue. And finally, you have to write about it. I've written over 200 opinions, 25 of which have been published. And I know how to analyze things as a group and then reach a clear, crisp decision when you're announcing that. All of these things are part of this question.
Thank you so much. Will?
Thank you. Judge Diaz, artificial intelligence or AI is not always a well understood and defined term. How do you define AI personally, and how do you think the court should approach using it in day-to-day operations?
Yep, it's it's a great question. Artificial intelligence means different things to different people. Now we kind of put it into categories of generative or narrow or agentic AI doing different things, right? And I think in the law, we also confront those different tasks. I'll give you one example. I am the chair of the Interpreter and Language Access Commission. Some courts are eager to adopt AI for interpreter and translation services, right? We are proceeding cautiously. We're not sticking our head in the sands, but we're proceeding cautiously because right now, as it stands, there is no closed universe of court hearings, court processes, with all the technical aspects of it that can be a data source for the interpretation, even of a language as simple as Spanish, let alone all the 170 languages that come through just, for example, the King County Superior Court. So we need to find these data sources if they exist. Then secondarily, we need to find validators. How can we validate whether or not the interpretation is being done accurately? Right now, we do that by human processes. We test potential interpreters. We run them through both oral and written exams. We then credential them. We then open up the space uh, to people to make complaints about interpreters, and we assess those using humans. None of that happens right now in AI interpretation. So using Google Translate or something like that might be good when you're ordering lunch in Tokyo or something, but it's a different level of importance when you're coming into your court and you're pleading guilty, for example, to a felony crime. That said, on the Interpreter Commission, we've already rolled out some basic AI tools. For example, Pocket Talk. We've distributed those with policy and training to our courts. So when someone shows up at the front desk, at least we can determine what language they speak and give them a little bit of basics. So it's a growing area of concern, but that's one way I would approach it cautiously, but maybe there's some opportunities there as well.
Thank you. Anita?
The Harvard Crimson recently reported on an emerging two-track clerkship system aligned on ideological grounds, with a distinctly different path to clerk for liberal versus conservative federal judges. How does ideological alignment impact the work of a judge? And how can we create and protect a nonpartisan bench? Since electing judges is an inherently political endeavor, how do we ensure that judicial races do not become de facto partisan?
This is a great question, and the premise of the question is accurate. It's unfortunate some of the federal bench is lining up in that way, but it's also lining up, unfortunately, for some courts, not necessarily our U.S. district courts, but for some courts, it's lining up in terms of judicial philosophies, as if there's one conservative judicial philosophy and there's another liberal judicial philosophy. This, for me, more than anything, points to the importance of our state courts. Our state courts are not like that. We do not have ideological tests for our law clerks. And we have a variety of tools. We recognize the complexity of the law and recognize that sometimes, yes, a close analysis of the plain language of the statute, which I've done, again, I've been on 700 appellate cases, 200 written, 200 opinions. A good chunk of them involve analyzing a new statute that the legislature has passed. And yes, sometimes we look at the plain language to get the intent of what the legislature is trying to do. But other times we look at broader principles, the legislative history, these other things. And really that's for me that those sort of basic tools of statutory construction, constitutional construction, and contract interpretation, those go to the heart of the judicial philosophy that I adhere to, which is American pragmatism. It is not originalism, it's not textualism. It is American pragmatism, which views the law as a living, breathing thing. It is an agreement in methods and in principles and in results that we have inherited from not just the federal constitution, but from our own independent state constitution. And we apply it in a way that is responsive to the needs of the community now. That's what the law is. It is a series of practices. And I've luckily had the experience of being over 25 years in the law, 10 years as a federal civil rights lawyer, and then now in my ninth year of judging to have applied these principles and tools. And I will continue to do that in a nonpartisan way, as much as one can do so in our current unfortunate environment.
Thank you so much. Our last prepared question will be asked by Will.
Thank you. Could you tell us a little bit about the continuing education requirement for judges? How do you proactively seek out furthering your knowledge and understanding of bias, diversity, inclusion, and accessibility? And how have you applied those to your work?
Yeah, it's a great question. So the continuing education requirement for judges is that you need to attend, 20 to 30 hours of CJE, continuing judicial education, every year. I meet that easily through attending our conferences and other specialized judicial education. But more than that, I meet that because I teach, and I have been teaching judges, law students for now, and other lawyers for now over 15 years. First with the Justice Department, I taught trial advocacy, I taught civil rights enforcement, and I taught a civil rights enforcement class at Seattle U from 2019 to 2021. And now I'm teaching, as I mentioned before, Washington constitutional law. Um, each of those classes, particularly the civil rights classes, but even the Washington constitutional classes, all deal with our groundbreaking state law cases that involve bias, diversity, inclusion, and accessibility. For example, we had probably 4 sessions on prosecutorial misconduct in GR 37, which you may have heard about, which is a new rule, relatively new rule that seeks to eliminate bias in jury selection originally, which was then expanded in a lot of other ways. At a more systemic level, I have served or serve now on 2 commissions. One is the Minority and Justice Commission, and that is the mission of that commission. Second, I chair the Interpreter and Language Access Commission, as I mentioned before, and that's to avoid national origin discrimination. So people who are non-English proficient can come into our courts and participate as fully as a native English speaker. Finally, I also serve on I served on the King County DEI committee, which created one of the first DEI policies in the nation, and now I serve currently on the Court of Appeals DEI Commission. But more day to day, I try to mentor. I try to engage with judges and people of all diverse levels, whether that's gender, race, ethnicity, national origin, disability, in all those ways. And I think it really has to be a full, all hands on deck approach when we're talking about these issues.
Thank you so much. We'll now move into the follow-up section. Sarah, I see your hand.
Yes. Can you tell us a little more about your experience handling appeals in the state and federal court, both as a judge and an advocate, and how this experience would inform your perspective and approach on the highest court?
Yes, great question. So when I was an assistant U.S. attorney at the U.S. Attorney's Office here in Seattle, I handled hundreds of cases from the beginning to the end. Like I said, most of it was in federal civil rights enforcement, so housing and education, employment discrimination, and my police misconduct case, which I'd love to talk about. But I would also handle the appeals as well. So I handled several appeals that went up to the Ninth Circuit Court of Appeals. I argued multiple times in front of that court. And then now as a trial court judge, as an appellate court judge, as you learned, I've authored over 200 opinions, 25 published, which means that I'm creating precedent under our common law. I've written 5 dissents, 1 concurrence. And I think the point of that, as I mentioned in my opening, is I'll be ready from day one. And that's really important right now because the issues that are coming before the state Supreme Court are of titanic magnitude. And I think you really want to support and endorse somebody who has the experience of doing all aspects of appeals up to and including, I substituted judges for the state Supreme Court a couple of years ago as well. So thank you.
Thank you. Is there another follow-up from our colleagues in the room? Sarah.
I can ask another one. You clearly have a wealth of experience as an appellate judge, but do you foresee any unique challenges or opportunities serving on the state Supreme Court, and sort of how would you approach those?
Yeah, such a great question. I'd say 60% of the job is the cases. That's reviewing the record, analyzing, talking to your colleagues, engaging in group decision making, writing opinions. That's like the day-to-day bread and butter of being a Supreme Court justice. But so much more is the platform that you're permitted to have and really being a leader for the court. Luckily, I've already done some of that work. I was the chair by myself for a while of the Interpreter Commission again. Justice Gonzalez and I now co-chair it. I also am a member of the Commission on Judicial Conduct, which ensures ethical behavior among our judges. We investigate and can discipline judges who engage in misconduct. That part of it is something that's super important to me. There are a lot of big issues coming down our court in the administration of justice, whether that's a criminal defense crisis or the cost of civil litigation or AI, as was mentioned before. These are real opportunities to take a leadership role at the court. And I believe I have the experience to be ready to balance those two things. Like I said, the bread and butter of deciding cases and also taking a leadership role over here in all these issues coming down the pike.
Thank you so much. Is there another follow-up? Because I'm going to probably put Will on the spot as a law student to ask you a question before we move to your 90-second closing. Is there another follow-up? Seeing none, Will, I'm going to put you on the spot to ask a law student question.
Yes, this is more of a self-serving question than related to your job description question. But you were talking about AI and how, AI is being used for translations now. In your opinion, do you think that in the future, in the next 10 years maybe, there could be a risk to trial lawyering job markets as AI for self-representation in court improves?
Such a good question, Will. In the next 10 years, no, I don't think so. I'll tell you why. AI can do certain things. It can review big records. It can review audio, like I had to do as an associate way back in the day. It can even find the best case for you, maybe, but it can't do what a human brain can do. We've been evolving for 4.5 billion years, right? When carbon first came together. And it's going to take a long time before it can engage in the wise counseling that is required of a human being when someone's confronted with an extremely complex problem in a new field. So I don't think it's going to be replacing lawyers anytime soon. I think there's an opportunity, as I mentioned at the very end, to use it selectively. So for the courts, it is an opportunity to do things like provide pocket talk for people who are limited English proficient. It's an opportunity to, review, look for typos and things like that for now. But it's something we have to proceed with very cautiously because the human brain can't be replaced with all of our morality as well.
Thank you. Appreciate it.
Thank you so much. Well, we've been delighted that you were here with us today, and we invite you to share whatever you would like as we close out our interview. Thank you.
Thank you. Well, first, I just want to thank you all again for taking part of the sunny, beautiful day to meet with me. And there's just a few things I just want to emphasize that I don't think we got a chance to as much, which I'm just going to emphasize three things just right off the bat. The first is that I'm an immigrant of indigenous descent, who again, I grew up back when Ballard was working class. There were still, there's still shipbuilding, machine shops, all sorts of things like that. And importantly, they were still people of Scandinavian descent who just recently immigrated. That's the community, one of the communities I came from, White Centers, where we moved down to so we could buy a house. We were just renting in Ballard. So we could buy a house in White Center. Second point I want to emphasize, I was a federal civil rights lawyer who defended the rights and freedoms of the most vulnerable, including from police excessive force. And it was President Obama who nominated me for that work. That's the second thing. And third, again, I'm the only candidate in the field who has both been a trial court judge and an appellate court judge. So I think I'll be ready on day one. And I think that for that reason, I've been supported now by 3 governors, Inslee, Gregoire, Locke, Attorney General Nick Brown, 9 Supreme Court justices, including a majority of the current court, and over 100 Court of Appeals and Superior Court judges around the state, nearly my entire bench. And finally, I do want to end where kind of I began, which is with my family. My dad, he was born in the slums of Lima, Peru, to a single teenage mom. And when he got here, he washed dishes. He was a janitor. He cleaned some of the buildings in downtown that I worked in as a lawyer. My mom, she was one of 12, grew up in a tiny 2-bedroom apartment in Lima. When she got here, she was a seamstress in Belltown when Belltown still had industry too at a luggage factory, and she stocked shelves at Safeway. My dad got his AA in North Seattle Community College, as did my mom. My mom went on to get her BA at UW. He became a machinist at Boeing for 20 years. My mom became a special ed teacher at Seattle Public Schools for 20 years. I can honestly say that my family has lived a version of the immigrant's American dream, and it's that dream that's at threat right now. And those opportunities for the next generation of Washingtonians, again, wherever they come from, that's what motivated my desire to go into public service. That's what motivated my desire to become a judge so that I could uphold the rule of law which is one of the things that distinguishes this country from, for example, my home country of Peru, where where corruption sometimes has been rampant and the judiciary has sometimes not been respected. So basically, I hope to preserve and pay forward our immigrant experience to the next generation of Washingtonians, wherever they come from. So thank you again.
Thank you so much. This concludes the formal part of our interview. We will stop recording and remove our spotlight from